All right, again, the good news is the next two chapters are Article 3, right? So in a way, it's kind of nice that we just keep plowing through it. So the next chapter is on holder in due course. And we'll talk about this. We're going to call this term HDC, holder in due course. We'll hear it a lot in this chapter. We'll hear it a lot in the next chapter. And we're going to talk about transferability. Because, you know, we just spent a lot of time talking about what a negotiable instrument is, what are the functions of negotiable instruments, and so on. But now we're sort of going to get into, well, one of the things that we didn't explicitly mention last chapter was the notion that if you meet the requirements, not if you meet, but if the negotiable instrument meets the requirements of being an Article 3 document, then one of the benefits of that is that the negotiable instrument can be transferred to other parties, subsequent parties, by negotiation. Oh, what? Negotiation is just another way of saying it can be transferred. So, you know, has anyone ever taken a check, signed the back of it, and given it to somebody else? Did you know that you negotiated a negotiable instrument? Wow, you did, okay. Who said that? Show off. All right, but yeah, right, exactly. You're endorsing, but what are you doing? You're taking a piece of paper and using it like money. Not just once, but twice or 3 times over. You're doing the very thing that Article 3 was intended for you to do, right? And that's great. You could do that. That's the idea of Article 3. And indeed, you do this by endorsing. And endorsing is a fancy way of saying you're signing and maybe putting some other instruction. That's what an endorsement is. And we'll talk about, just because we cannot leave well enough be, we have to talk about different types of endorsements, right? And I know everyone's read the chapter, of course, beforehand, and you all know about these different types of endorsements. I'm going to just give it different names just to kind of complicate things in your heads a little bit more, because that's what we do in business law. All right, what is an assignment? In this context, an assignment is the transfer of rights under a non-negotiable contract. So, step back with me for a minute. If the instrument is a negotiable instrument, it meets the requirements of Article 3, technically what you're doing is you are negotiating that instrument. But if you blow one of the requirements of Article 3, what do you have? You just have a non-negotiable contract. Doesn't mean that it's, that doesn't mean that it's a piece of junk. It is still a legal instrument. And can that be transferred to another party? The answer is yes. It's just that it's not subject to Article 3. It is subject to common contract law. You can still assign it. And now if you go back and think about Business Law 1, we talked about assignments, right? We talked about an assignment being where the rights of one party, if you're talking about money, there's no personal services involved, from one party to another. And now, yes, one party is the assignor, the other party is the assignee. That's just plain old contract law. I mean, it's just, yes, we're talking about Article 3, but I don't want people to forget that if you blow something and you're not Article 3, so what? You've got a contract law governed contract. It's just that it's subject to plain old contract law. Okay. And again, a non-negotiable contract is a contract that lacks one or more of the requirements. What if you put in your promissory note some condition? You no longer have an Article 3 negotiable instrument. What you have is a contract subject to common law. All right. What is negotiation? Remember, you know what negotiation is. Negotiation is a term that means that, both parties try to advance their interests and so on. Yeah. That is the English definition of negotiation. The Article 3 definition of negotiation is the transfer of a negotiable instrument from someone other than the issuer to a person who thereby becomes a holder. What? You said you've endorsed a check, right? This was a check made out to you as a payee, and you gave it to somebody else. All right. You have just given a check to a third party, and that third party is a holder. A holder. And I use the word holder particularly because it's a term of art in UCC Article 3. That holder could be a holder in due course or an HDC. And we'll talk about when that happens and how that happens, but is it better to be a holder or a holder in due course? It's better to be a holder in due course. The reason is you get greater rights, perhaps greater rights than the party that even gave it to you. What does that mean? It means, and all the rights that we're concerned about with a negotiable instrument is to get paid, right? If I get a check, I don't want that check to do anything for me. I don't want that check to give me a back rub or anything like that. I just want that check to give me money, right? That's its only function, right? That's it. So when I'm talking about rights, it's just like, what happens, well, we saw that in the Las Vegas case, right? Sometimes people write a check and it bounces. Sometimes people write a promissory note and they default, right? So in a perfect world, we couldn't care less. If everyone kept their word, if everyone had ample money, we wouldn't need to be here on a Saturday morning. But the thing is, that's not always the case, right? So the notion that somebody else that gets something endorsed to them could actually have a higher status if they do certain things, as we'll see, and be a holder in due course, means that they could have rights against parties that are trying to use defenses like, well, the casino took advantage of me, or the fact that, I mean, it's a promissory note, but I got bum goods or something like that, right? So yes, for now, understand that if you have an Article 3 negotiable instrument, a holder in due course has greater rights than just a plain old holder. Okay? Okay. Now, we talked about words like payment on demand and order and so on and so forth. Let's sort of understand a little bit about how negotiable instruments are payable. A negotiable instrument could be payable to someone specific, a specific payee, or it could be endorsed to a specific payee. You could write out a check, you could sign your name to it, you could write out the amount, and you could make it payable to cash. Have you done that? Something illegal about that? Not at all. Something not so wise about that, possibly? Possibly, if it falls into the wrong hands, because it is not an order paper, meaning there's no specific person to whom it is payable. But most of us, when we write out a check, we write it out to someone. Anyone just endorse the back of a check and given it to somebody? Right? Or, better yet, when you endorse a check, do you sometimes say, pay John Smith, and then sign it? Now, that is, I'm sort of giving you different examples of, you have something called order paper and bearer paper. When there is someone specific to whom payment is to be made, whether it's a check made out to someone, whether it's endorsement that is followed by someone specific to whom it's supposed to be paid, what you have is order paper, right? And all you have is someone specific that needs to be paid. And there, all you need to do as the endorser is to give it to that person, delivery, and give it to them with the proper endorsement. All right? You're making an order paper. Contrast that to bearer paper. And the word bearer is someone who just bears it, has it, right? That's where the name is derived from. An instrument that is not payable to anyone in specific or endorsed to anyone in specific still is negotiated or transferred the same way by giving it to that person, delivering it, but without any specific endorsement. Again, nothing wrong with it. Article 3 is completely okay with it. It's just that the liability issue is there. Because if you give it to your friend Joe, Joe drops it, and the thief gets it, bearer paper is negotiable by that person. That's why people sometimes endorse it to a specific payee. And here's a case. Is this I think I know what this case is. This is a law firm case, right? If I'm not mistaken. Court of Appeals of Georgia, for those of you that follow along with me and care if it's state or federal, it is a state court from 2004, involved a company, a law firm, against a bank. And the question is, did the bank properly accept blank endorsed bearer's cashier's check from the company? Anyone want to fill in the gaps of this case a little bit? My volunteers, don't call out all at once. Who remembers a little something? Thank you. Well, I wouldn't say it's a blank check. It was a cashier's check, and you know, and let me just fill in the gaps a little bit. You know, law firms sometimes get checks, large checks, given to them, not to go to town with, but from clients that maybe want to buy a piece of property. So the law firm is acting as a trustee, just as an in-between party to go to the closing, but they're not going to sit on the check. They're going to put it into their bank account, and then they're going to write out a check at the closing on behalf of the client. So, you know, they have an employee working for them, and the employee takes the cashier's check, endorses it, deposits it. Obviously, there's fraud going on. There's that. Okay, so that's what happened. Well, the certified checks, we're going to get into that, but here assume that it wasn't. I mean, this is all bad practice. These are all, somebody should have been really, somebody was sort of asleep at the wheel here. I mean, you know, they weren't sort of cognizant, but they were taking risks, but they weren't doing anything illegal. But you've got a rogue employee, an employee that is defrauding the law firm. And at the end of the day, the bank is getting a check that is endorsed in blank, but they're basically depositing and letting the money funnel through properly. And the question is, when the law firm now wakes up and, you know, is getting sued by its clients for monies that have gone missing, wants to sue the bank. You might say, why not just go after your employee? I'm sure they're doing that too, but even if the employee can be found and prosecuted, you know, I mean, the money is in, I don't know, gone, or whatever. But they're trying to go after the deeper pockets. They're saying, bank, you did something wrong. You shouldn't have, you know, taken or funneled these checks in the first place. And what does the court say? The bank didn't do anything wrong, right? There's nothing wrong. I mean, maybe it's bad business practice for the parties to be doing blank endorsements the way they did, but the bank was just following UCC laws, UCC rules. There's nothing, you know. So I mean, it's a case of trying to show. And you know, when you sort of read a little facts of the case, it doesn't necessarily tell us the full picture. This is not the whole decision. You know, there might have been other facts that maybe they were trying to argue that the bank should be put on notice. That if you're getting that many checks endorsed in blank, maybe bank, you should have been able to pick this up. But here, the bank's defense is, look, we process gazillion transactions a day. It is not our responsibility to flag it. You know, this was not a private account. This was an ordinary account, and we didn't necessarily do. So, I mean, whatever the facts might be in this case, the holding is pretty clear. There's nothing wrong with the drawee processing checks that are endorsed in blank. But it's a lesson learned that endorsements should be protected in some ways. Yes. Give it to me again. So you're saying as a matter of normal business? Yeah, it's not that unusual. But you know what was unusual about this? This is an attorney trust account, right? So the difference here is that maybe with these types of funds and the likelihood of potential abuse, and you might say, well, the law firm is trusting its own employees. They're walking over to the bank. But the problem is, should the party have contemplated that they could be stolen from? Should they have, you know, said that, you know, maybe given instructions to the bank that for the attorney trust account, make sure that it says payable to the trust account, don't deposit it. Could they, who is the party that could have prevented this fraud? Look, fraud happens. The question is, who's going to be left holding the bag? And here, and I think you're sort of going, banks do this all the time, right? And the bank shouldn't be liable. If anyone that could have potentially taken steps, it was the law firm itself. No, the issue is that the employee that they trusted perpetrated a fraud. And the fraud was not something that the bank should be responsible, holding the bag for just because it took a blank endorsed instrument. I mean, I think that's the issue. The issue, the way the personal account worked here was you're supposed to take that check and deposit it into the trust account. What she did was she basically endorsed it and then transferred the money into her personal account. It was fraud. But, why is it the bank's responsibility to be held holding the bank? They didn't do anything wrong, is the issue here. But somebody did something wrong. It was the employee. Well, what can you do? But the question is, who's responsible for these monies? Because a law firm has to pay back its clients, even though their employee is in Bermuda and it cannot be found. And the law firm is trying to see if they can make the bank be partly responsible, and the law says no. So here, it's unfortunate that somebody, even though they weren't personally responsible, the law says, well, the buck has to stop somewhere, right? There's liability along the way. So again, not a perfect scenario, but acknowledging that there's going to be liability somewhere. Okay, but here the point really is endorsements, right? What are the different types of endorsements? What do they do? Well, an endorsement is a signature and other directions written by or in behalf of the holder somewhere on an instrument. And by the way, it just sort of occurs to me, how could the law firm have avoided it? Maybe on every check that they get, before they handed it over, they could write for deposit only in this account. Then there was no way that it could go anywhere else. And in fact, that's what business practices would dictate when you are entrusted with somebody else's down payment or something like that. So it's not like anyone that did anything illegal, but the question is, did they take all steps that they could have possibly contemplated with the notion that sometimes bad things and bad players are involved? Okay, endorsement. So, it's a signature with some other directions written by or on behalf of the holder somewhere on the instrument. And I always sort of give the check example because we know where to endorse that. It's on the back. The bank tells us where to do it. They even draw out the lines to do it. Could a promissory note be endorsed? It's a negotiable instrument. And the answer is yes. So a promissory note is just a document. It doesn't have to be in any which way. How do you endorse that? You sign it. You add another piece of paper to it. There's no magic to the way it happens. And by the way, notes are sold from one party to another oftentimes. Why? Because the party that is the payee wants to get paid on it quicker, right? They'll sell a bunch of notes to another financial institution for a few pennies less on the dollar in the notion that they get paid today, and the other party buys it because they can get paid later with interest. Right? So that happens all the time. So how do promissory notes get endorsed? Well, any which way that makes sense under the circumstances. On the back of that note, electronically, through any which way. Right? So the point here is that it's not just checks that get endorsed. So, but when we're talking about all these different types of endorsement, we are thinking about a draft or a check in this case, and the signature may be by itself. Right? That's what a blank bearer endorsement is. It could name an individual to whom the instrument is to be payable. I get a check and I write on the back, pay to Mary Smith, signed my name. Or be accompanied by other words like, for deposit only. Right? Any of those sort of things could be fine. Endorsements are required to negotiate order paper, but they're not required to negotiate bearer paper, because we know bearer paper is negotiated by delivery. We don't need any special things because, financial institution can pay on it based on the type of signature that is made. All right, there is a lot on the slide. It's almost difficult to kind of read it off of the slide. I don't want anyone to get afraid of this. All this is doing is summarizing the different types of endorsements. Not every slide in the deck is created equally, right? Some things have very little on it. This one, star, because it has a lot of material on it that has been summarized. What could be 6 different slides is in one, to kind of look at it all at one glance. And we'll talk about each of these. They're basically these types of endorsements. Get familiar with the terminology. Blank versus special, okay? Qualified versus unqualified, okay? Restrictive versus unrestrictive. There's a theme here, okay? We've already talked about blank versus special a little bit. When you endorse, for example, a check with just your signature of the payee, that creates bearer paper, as we've said. And what kind of an endorsement is it? It is a blank endorsement. Blank means just your signature, no other instructions. But if you specify who it's going to be paid, if you say, in addition to your signature, for example, pay to the order of John Smith, pay to John Smith or Fred Rowe, whatever the case might be, and then sign it, you have named someone specific. By the way, it doesn't have to be a person. It could be payable to a business. Pay, real estate developer company signed, right? That is a special type of endorsement. It is called a special endorsement. And you've created not bearer paper, but order paper, because it's only payable to that party. Someone else who steals it cannot put it into their personal account because the drawee is on notice that it is only payable to that party. Okay? So that's the only difference between blank versus special endorsement. But what else can you do? What other restrictions or what other words can be put onto an endorsement? Well, endorsement could be qualified or unqualified. Okay, what does that mean? Well, most endorsements are going to be unqualified. The party that is endorsing is not going to be able to disclaim their liability, because most parties that are named on an, if I'm a drawer, if I'm a payee, I'm going to be liable in some respects. But it's possible for certain types of payees to qualify to limit their liability. Stay with me for just a second. And here are the magic words that you should sort of highlight, circle: without recourse. Without recourse meaning you can't come after me. Wouldn't we all like to do that? Wouldn't we all like to sign without recourse and then sign our name and say, that's it, if I've learned nothing else in business law, I know how to sign my checks from now on. And I'm going to make sure that I sign without recourse, because then I'm out of it. A little bit of bad news. It doesn't apply to everybody. It only applies to, and again, if you read banking agreements or customer agreements, they will say that that won't work against you, or language to that effect. But it does work for certain types of parties. Go back to trust accounts for a minute, okay? And here I'm not talking about, and think back to the law firm. And here I'm not talking about an employee stealing from the law firm. Just now, let's just sort of think about it in other terms. The law firm gets a check from their client, right? And they want to deposit it into the trust account. The check bounces. The law firm is just acting as a conduit. They're just acting as an in-between party, right? So on a lot of these trust accounts or fiduciary accounts, it is acceptable and it is common practice and it is given effect when that party signs without recourse. Because what they're saying is, if this check bounces, do not come after us. We are not legally liable. Our role is a facilitator. So those kind of facilitating parties, whether they're trust parties, fiduciary parties, and so on, have the ability, and they exercise that ability to say without recourse, meaning, we're not involved in this except to act as a in-between, go-between party. So, you could adopt this practice, but it's without any legal effect. It really only applies to certain kinds of payees. So yes, qualified, unqualified, but most of us will always sign unqualified because there is a possibility that we could have liability. What's the last one? Restrictive versus non-restrictive. Look, if all you say is pay John Smith, your signature, or just your signature, what you have is just a non-restrictive endorsement. But if you put something restrictive, such as, examples, pay to John Smith only, you've created a restriction. Or if you say something like for deposit only, you've created a restriction. Or if you say something like, and this is one that's not on the slide, no further endorsement, you've created a restriction. You've just taken a negotiable instrument and stopped it from being negotiable any further. Right? So these are, again, depending on the circumstances, things that a holder can do when they're trying to endorse a negotiable instrument down the line. Yes? Oh, that's a good question. Isn't that a condition? And didn't we say that condition on payment is not the issue? Condition on the performance is an issue. So the issue, and it's a fine line there. Right? But you could have conditions on who endorsements going further, but the types of conditions that destroy negotiability is I will only pay if something like this happens. This is not that kind of a condition. This is a condition on can this instrument be paid to a certain party. Those are endorsements, and those are perfectly acceptable. So blank versus special, we understand. Unqualified versus qualified, we understand, knowing that without recourse is only available to certain parties. And restrictions such as further endorsements, who do we pay, could it be just for deposit purposes or something like that, is something that is acceptable with respect to negotiable instruments. All right, so this is an important slide for terminology. It's not a particularly complicated slide, but it is one that we need to get comfortable with the terminology. Here's some sort of random stuff that we sort of have with respect to Article 3 rules, and we'll see this more when we talk next class with Article 4, banking system, and so on. We're not perfect. Typewriters, did I just say typewriters? Those doesn't exist. Typing is not perfect. We make mistakes, and the question is, does the fact that the name of a party, and assuming there's no fraud involved or anything like that, the fact that you misspell the name in some way, but it's understood who you meant, somehow destroy a negotiable instrument? It shouldn't, because isn't the whole point of the Uniform Commercial Code to be flexible? And the answer is yes. So, and has this ever happened to you? Someone wrote out a check to you, but they misspelled your name? Maybe there's an E at the end. Maybe your name is Lily, and you spell it with 2 L's, and there's only one, things like that. No problem. How do you endorse it? Sometimes you endorse it with, banks have certain rules with respect to this. You endorse it both with the misspelling and the real spell, whatever the case might be, or you correct it or something like that. The answer is no big deal, right? Assuming, again, that there's no sort of fraud, you don't destroy negotiability of a Article 3 instrument simply because of a misspelling or something like that. Those can be corrected. Can you have more than one payee? Right now we said that, payable to John Smith or payable to Mary Jones or something like that. Could it be more than one party? Sure, why not, right? And then there's sort of rules with respect to multiple payees. Well, what if you wrote down payable to Corporation A and Corporation B? Who has to endorse? Both. The and requires both. What if you, and people have sort of done this, write out a check to, maybe it's a couple. You say John or Mary. Either one. What if you put a slash? What does a slash mean? John / Mary. That's equivalent of or. Banking rules recognize it under Article 4. Article 3 recognizes, again, the fact that you have multiple payees just perhaps means from an endorsement perspective that maybe it's one, maybe it's both, depending on how those multiple payees are specified. Simple black and white rules, that's what the UCC is. Okay, now back to this notion of holder and holder in due course, right? So who is a holder? A holder is someone who has physical possession of a negotiable instrument that either is in their name or issued in their name or is endorsed to them, either in order or bearer, right? What does that person have a right to do? Well, that person has, if we're talking about a non-negotiable instrument, has the same rights as an assignee. I mean, they have the same rights as someone who gave it to them, right? And that person is subject to all the claims and defenses that can be asserted against a transferor. So, for example, we just finished talking about Article 2, that people make warranties. People say that if I'm selling you something, it's going to meet a certain condition or requirement. What if I paid someone with a check that basically said that, in order for my purchase price to be good, I'm actually getting a car that is, driven 25,000, not 75,000. And let's say that somehow the negotiable instrument that I have is not a negotiable instrument. I somehow have destroyed its negotiability. And I basically endorse it and I give it to a holder. The problem with being a holder, and stay with me, I know I'm sort of layering out a lot of facts. The problem with being a holder is that if the seller breached a warranty, the holder is subject to the same claims and defenses, meaning that if the seller isn't someone who could legitimately get paid because they breached a warranty, then someone to whom the seller has endorsed that check that they got paid with is subject to the same claims, right? That is why it is better to be a holder in due course instead of just a holder, because if you're a holder in due course, and we'll see what a holder in due course is in a minute, then it doesn't matter that the buyer and the seller had a dispute. When a seller endorsed a check to me, I don't care. Those kind of personal defenses may be something they need to worry about. I still need to get paid on that check. Because why? I am someone who took a negotiable instrument for value in good faith, and I had no idea that there was an underlying issue, and frankly, no offense, I don't care. I'm a holder in due course. So I take it free of all of those claims, and those types of defenses, those personal defenses will not work against me. Universal defenses, we'll see that in the next chapter, what they are in a minute, could work against me, but the fact that there was an underlying dispute, I don't care. That is a personal defense. And I could get greater rights than the transferor, and I did. Right? The seller may not have been able to cash that check, but I can as a holder in due course. So again, what is this mythical holder in due course status? What does it take to be a holder in due course? It takes good faith, clean hands, and a lack of knowledge, right? So in order to take as a holder in due course, you have to take for value, meaning that, for example, if the used car dealership gave me the check, they were paying me off, for example, for a debt that they owed me, right? It wasn't a gift. I was getting it for value, meaning, I supplied goods to them. They paid me by an endorsed check. They paid value. In good faith, meaning it's an arm's length transaction. There's no funny business going on. Without any notice. Look, if I'm aware of the underlying dispute, then that's an issue. If I know that there's something wrong with the underlying negotiation, if I know that there is some forgery involved or something, but if I have no idea and no reasonable circumstances are putting me on notice, I'm a holder in due course. Okay? So it's sort of this sort of honest, I don't know, remember the good faith purchaser for value in the last chapter, in the last class and so on, meaning why should someone, if all we're talking about a negotiable instrument being negotiated and transferred, if I'm someone that doesn't know and I've elevated myself to the status, meaning, I took for value, I took in good faith, why should I be held, in someone else's dispute that happened before the time that I got this instrument? So that's why it's better to be a holder in due course than it is just to be a plain holder. And we'll play with a couple more examples. So, okay, maybe I got ahead of myself. What does it mean to take for value? It means that you did something to get that check. It was owed to you as payment. It wasn't just gratuitous. What does it mean to take for good faith? I mean, just circle the word honesty. There's no hanky-panky going on here. There's nothing that would sort of cause antennas to go up. It was in the normal course of business, arm's length transaction. And again, you didn't know of any defect with this instrument or with the underlying issue. You didn't know, there was nothing to put you on notice that there was something wrong with this negotiable instrument. You meet those requirements, you are a holder in due course. You don't meet those requirements, you are just a holder, meaning your payment status might be in jeopardy. It's not as black or white. There is this concept, and again, I don't go into this much detail, but I always feel like, even if it's an obscure concept, I should at least explain it to you in case down the road it becomes relevant. Maybe it's on a CPA exam, maybe it's not. I don't go into this much detail, but let me explain to you what the shelter principle is. Everyone knows taking shelter, right? The shelter principle is this notion that says, under the UCC, that a holder who does not qualify as a holder in due course in his or her own right may become a holder in due course if they take the instrument through a holder in due course. What? Okay. How likely is it? Not very likely. Okay, the reason I sort of want to step back and say it's very unlikely is because the days of negotiating a negotiable instrument down the road and doesn't make sense in today's world. We have a very different credit economy that, I mean, this is almost like before credit cards, before lines of credit, when promissory notes were actually acted as cash and you had to, it just isn't relevant as much today, which is why these principles are not as relevant today. But the notion of a holder in due course or a shelter principle could be the following. It is possible to get an elevated status even if you're taking as just a holder. I mean, the best example that I can kind of think of is, let's say someone is endorsed a negotiable instrument, but they didn't take for value. Okay? They didn't take for value because it was a gift. It was just someone just giving it to them. They can never be a holder in due course, right? So, a holder could sometimes get an elevated status if the person who endorsed it to them was a holder in due course. So the shelter principle is just elevating a holder to a higher status. Now, again, you could have all you really need to know if down the line is somewhere in the back of your mind, know that the shelter principle just elevates a holder to a higher status because they took from a holder in due course. That's all. And I know we have a lot more to absorb, so I'm not going to spend a whole lot of time on obscure principles. I guess I already explained it here in the slide. I got ahead of myself. But what we really want to focus on is understanding the liability of the parties. And really, that's what the next chapter is all about. Now that we know the various types of endorsements, now that we have a little bit of an idea of holder versus holder in due course, we'll come back to that in this chapter, let's understand liability, right? And liability and defenses are important because, again, as I said, if things go right, terrific. There's nothing to talk about. It's when there's an issue. There's an issue with the underlying payment. There's an issue with the negotiable instrument itself. The question is, who has liability? Who's going to pay? Sometimes the party, as we've seen, perpetrating the fraud is no longer around. Then what? Then where does the liability fall, right? And there's, as we see in this chapter, there's the notion of primary liability. There's the notion of secondary liability. Any questions so far before we delve into that? Is everyone's head spinning with all this terminology? Again, I'm trying to keep it high level. I'm trying to repeat myself so we get comfortable with drawer, drawee, maker, payee, holder, holder in due course. Those are the bigger concepts here, right? So try to stay with me on those. Okay. Remember we said that a negotiable instrument has to be in writing and a negotiable instrument has to be signed. Who signs it? If it's a check, who signs it? Drawer. If it's a note, who signs it? Maker, right? Okay, those people have liability because their signature is on the negotiable instrument. And it's called signature liability, as if we needed to name that. Liability in which a person cannot be held contractually liable unless they've actually signed it, right? You're liable under UCC. You're also liable in contract liability simply by agreeing to be bound by what the contract makes you do, in this case, to pay, right? That shouldn't come as a huge shock that when we sign a check, when we sign a promissory note, that we are actually agreeing to pay under the terms of that instrument. And again, I know some of it is repetitive, but it doesn't hurt sometimes to be repetitive because the concepts become much more concrete in our understanding. A signer is a person signing an instrument who acts in the following capacity. A maker of notes of deposit. Remember, that's the bank. A drawer of drafts or checks. We've already said that. And by the way, it could actually even be the bank who certifies or accepts checks or drafts. You know, cashier's checks, you know, sometimes banks will guarantee payment on a check. And when they do, and we'll talk about cashier's checks and certify, they're actually accepting liability. And they're happily accepting liability because they have the funds already. No big deal. Don't feel sorry for the bank. An endorser who endorses the instrument. You know, we've already seen that unless you can sign as a qualified endorser with words like without recourse, you're actually taking liability when you do that. You may be down the line, but you're taking some liability. An agent who signs on behalf of others. Could be that the agent could be liable along with the principal, depending on, and we'll talk much more about principal agency law as we go along. And this other name that I've never seen before, have you an accommodation party? Where did that come from? What's an accommodation party? What do you think it is? Say that again? Parents. You're getting hot. What do parents sometimes do? A cosigner, a surety, a guarantor. And why do those poor people get dragged into this mess? Thank you. Well, that's one good reason. But if we're actually, let's take parents out of it and let's make it just another party. Why would someone agree to co-sign, become a guarantor, become a surety? Why are they needed? And because a financial institution says, go get somebody like that. You know, you as the borrower are not good enough for me. It's not that there's anything wrong with you. You're just financially not good enough to be a good enough credit risk. And a very good, an accommodation party is someone who agrees to be on the hook along with a drawer or a maker or someone. Okay, not always needed, but sometimes have to be dragged in. They are taking on liability as well. And again, we start to see some things that are the concepts that we've been around over and over again. We've said already that, we're talking about signature liability, but a signature, again, please, I've said this several times, you've heard this several times in Business Law 1, doesn't have to be paper to a writing instrument. It could be any sophisticated, technologically advanced electronic means as well, right? Yes. Sure. He didn't sign the check, but they constantly send you checks. Could be, could be. Depends. So the question is a sort of a practical question. You have an ongoing business relationship with a party, and you have lots of checks that they send to you for payment. And who hasn't done this, that you sometimes forget, to sign off, and you get a check, and it's made out for the same amount. Let's say it's, every month, every 10 days, and this one just wasn't signed, but it's made out to the same amount. You have a signature on file, and you basically execute that, and you deposit it. Have you done something, quote unquote, illegal by not notifying the party of that? I think it's how do I answer this? The answer is depends. Is it a good practice to do it? Probably you should. Are you absolutely required? I mean, I would argue from a legal perspective that it isn't necessary. If this is such a long-standing business relationship, there is nothing to indicate to you that it would have been any different this time. They mailed you the check. They just, do you have to go through and add that to your to-do list? Probably not. I don't think you've done anything wrong. But if it's a very new relationship and it's only then maybe. But again, the facts that you're suggesting to me doesn't indicate to me that you have an affirmative duty to notify. That's my take. I mean, maybe there are those who might disagree with me. But even I would, as an abundance of caution, do it. But the fact that you didn't do it or your employees didn't do it, I don't think that, that somehow you've done anything wrong there. You can.
I mean, I know you can do it with the insurance companies because they send the doctor checks directly.
Right.
But as a person that actually gives you a check.
I think it's possible that you could even, dare I use the word, not forge their signature, but yeah, you could. I don't think there's. Again, it's all in good faith. It's just, again, UCC doesn't want contracts to fail. You could print the name and just go with it. Remember these days, how are checks deposited? Does anyone really? They're just put into a scanning machine. Will it matter? I don't. Again, I mean, let me go out on a limb and say I. Correct. But I mean, again, I get paid every 10 days, and it's been going on for the last 16 months. I have, one check in the middle didn't get signed. Am I going to stop the presses over that? There's nothing to indicate to me that this was anything other than a human error. That's all. So I think we're cool with that. All right. So we've gone through a signature. It's nothing magical. It's no authentication. Again, everything I'm saying is on the up and up. There's no forgeries. There's no anything like that. Okay, liability. The word in the law that we all sort of shudder for at times. Liability. Liability is what it's all about. It's what brings us to business law, right? It's when things go wrong. Right? So, yes, we understand the basic parameters of the rules. Now let's talk about what happens. Who bears responsibility? And here, there are two types of liabilities with negotiable instrument. Primary versus secondary. We get that, right? Primary is first tier. Secondary is second tier. So who has primary liability? Primary liability is absolute liability to pay a negotiable instrument subject to certain universal defenses. We haven't talked about those yet. Leave them off till the end. It's not a big deal. Okay, so there may be a reason why a negotiable instrument doesn't have to be paid in certain very, very, very specified circumstances, but generally this is absolute liability. Who has it? The maker of a promissory note, and yes, a maker of a CD, but can we please stop talking about CDs? They're so unique and one-off. The maker of a promissory note does it shock you to know that in a two-party instrument where you are the borrower, you have primary liability? That should not be shocking. You would expect that to be primary. primary liability on the instrument, unconditional promise to pay amount stipulated on the note when due. You are absolutely liable, again, subject to only certain universal defenses. And let me not keep this a mystery. One type of a universal defense, for example, might be that the person making the promissory note, oh boy, was of diminished mental capacity, right? That is a defense under contract law. That is a defense under negotiable instruments, which are nothing more than a type of a contract. If someone doesn't know what they're doing, the law cannot legally hold them responsible for that. What's that? Yeah, that's capacity. That's exactly right. Diminished mental capacity. Minority, meaning lack of, you're less than the age of, So yeah, I mean, those are universal defenses that you might say, well, that's not fair. Someone who's 17 3/4 gets away with it. Again, you got to draw a bright line rule somewhere, and 18 is the bright line rule. Okay. So we're still talking about primary liability. No party is primarily liable when a check or draft is issued. Does that surprise you? It's actually secondary liability. But if the drawee accepts a draft or a check, the bank is primarily liable. And again, here we're only talking about things like certified checks, which we'll talk about in the next chapter. I mean, again, where the bank says, unconditionally, we will pay, right? Sometimes have you done business where the party on the other side says, do not give me a personal check, only give me a certified check. Why? Because they do not want to even deal with the notion that that check could bounce. And when you give them a certified check, you're giving them a guaranteed payment because the bank essentially has set aside the funds. They are absolutely going to pay. So there, that is primary liability on the bank. And that's not a big deal because the monies are already there. And again, same thing on a cashier's check. The issue of a cashier's is primarily liable because they've gotten paid on it already. All right. So now let's talk about secondary liability. Liability is liability, whether primary or secondary, right? It's just that front line versus second line, secondary tier. All right. Secondary liability is liability on a negotiable instrument that is imposed on a party only when the primary party will not pay or defaults. So if the maker of a promissory note defaults, then the responsibility goes to someone else. And that someone else might be, who said parents, could be the cosigner, we'll see, could be the accommodation party, among others, right? So this liability is similar to the guarantor of a simple contract, right? If someone guarantees somebody else's debt under a contract, the guarantor is liable. If someone guarantees a debt on a negotiable instrument, they're liable. They may be secondarily liable, but they are liable. And this could also be, now go back to the terminology, unqualified endorsers.